Good morning. Good morning to those of you who've joined us here at Tiller House. Good afternoon and good evening to some of those who are joining us online. My name is Michael Cooper. I'm the Executive Director of the American Society of International Law, and it's my pleasure to welcome you here to Tiller House. Normally at this point in the show, I would make a big speech about the American Society of International Law and encourage you to join. But I think simply watching this panel today will be reason enough for you to consider joining if you're not a member already. So I'm going to, I think all of our speakers, we have an esteemed panel this morning, I have to say, and I think probably everybody online and everybody in the room already knows these folks. But for those of you who may be new to the society, I will take just a quick minute to very, very briefly introduce each of our speakers. So I'd like to start out with Mark Ellis. Mark is the Executive Director of the International Bar Association, which is a leading international organization of bar associations, law firms, and individual lawyers. They have more than 80,000 individual members and hundreds of institutional members around the world. In various capacities, Mark has provided technical assistance, advice, and leadership to numerous international criminal tribunals, including the International Criminal Tribunal for the former Yugoslavia, the Serbian War Crimes Tribunal, the Iraqi High Tribunal, ICTR, ICC, and others. And I also just want to thank Mark because he reached out to us to see if he could jointly host this session. This is the first of a series of sessions that the IBA will be hosting around the world on this particular issue. So we were really honored to have Mark and his team join us. Next, I'd just say a word about David Crane. He was the founding chief prosecutor of the UN Special Court for Sierra Leone. David's here on the screen with us. Was the world's first hybrid international war crimes tribunal. And David is well known for successfully prosecuting the first sitting African head of state in history, President Charles Taylor. I'll follow that with our second David. Ambassador Shepard is a senior fellow at the Council on Foreign Relations, where he focuses on international law and international criminal justice. Professor Schaefer was the first U.S. ambassador at large for war crimes issues and led the U.S. delegation to the UN talks establishing the ICC. He has negotiated the creation of 5 or so criminal tribunals. So you can count them on one hand, but we're getting close to maybe needing to use 2 hands for that. Jessica Kim is a former special prosecutor for the crime of aggression at the U.S. Department of Justice. She also served as DOJ's resident legal advisor for Romania and Bulgaria. Jessica served as United States Assistant Attorney for the Southern District of Ohio, where I'm from, so we have that in common. We'll talk about that. I also just want to quickly point out that she had received in 2018, she was presented with the Attorney General's Award for Outstanding Contributions by a New Employee, which recognizes exceptional performance and contributions by only one employee within the DOJ, which at that time at least had about 115,000 employees who had served for less than 5 years. So that's quite extraordinary. She's had other recognition as well. So she's the youngest member of our panel. We have great expectations of her. Andrei Kostin, who is also on the line with us, was appointed as Ukraine's Prosecutor General in July of 2022. Hello, Andrei. It's been a while since I've been able to see you. It's good to see you. He led the country, Ukraine, through the early years of the war with Russia. He championed the investigation and prosecution of Russian war crimes with a human-centered approach to criminal justice, which all of us have deeply appreciated. And I can also say that during his tenure, Ambassador Kostin really became a global symbol of prosecutorial independence and integrity. I'd like to start off this panel. So let me just briefly say that our goal here is we want to spend about 40% of our time thinking about how we got here and about 60% of our time thinking about where we go from here. But I'd like to lead off with Ambassador Kostin to talk to us about this very moment that we're in now. Where are we? Because there were some very important developments that happened in Europe and Strasbourg in the last 24 hours, in fact. So I thought that Ambassador Kostin could talk to us about the most recent developments, where we are at this moment in time, some of the challenges that we face in developing this tribunal, and also why any of this matters, both for Ukraine and for the world. So Ambassador Kostin, I'll turn the floor over to you. I know that you won't be able to be with us for the full hour, but we'll appreciate any leading remarks that you can make. Welcome.
Thank you so much. Thank you so much for your kind introduction. And of course, thank you for the IBA and American Association for International Law to organize this set of events. And I will be very frank now to say that when Mark informed me about 26th of June, as a launch of this series of events in order to support the creation of a special tribunal for the crime of aggression, I knew at that moment that it could be that on these dates or even before we will have an agreement signed with the Council of Europe on the creation of the special tribunal. But it was so how to say, unclear if we will manage altogether to make it done. And I just wanted to say at the beginning that really hundreds of people globally in Ukraine, in Council of Europe, European Commission, the member states of the core group, many experts, lawyers, Mark, members of the International Center for the Prosecution of the Crime of Aggression, Jessica, very glad to see you today. And our colleagues are working here in The Hague. I visited them just a couple of weeks ago in Eurojust. So hundreds of people work hard in order to make it happen. And I want to commend each and every and all of them because we did something unbelievable from the very beginning. Because you know that historically, I said sometime that I have a collection of arguments why this tribunal should not be created. And this collection of arguments with which we worked hard openly with our arguments, legal, political, and also on expert level in order to persuade those who at that moment or at some moment were not ready to support this idea, in order to persuade them to be with us, because it's critically important that special tribunal for the crime of aggression should be of international nature. It's critically important that it should be supported by the number of states, by the big number of states, large number of states, I'm sorry. And it's critically important that it should fill in the gap in the system of the international accountability for the international crimes committed by Russia against Ukraine and Ukrainians. So thank you for all of you, and thank you for all those who are not presenting in person or online. But this work was really incredible. And yesterday, of course, after the visit of President Zelenskyy to The Hague with a substantial bilateral program, and of course very difficult meetings on the summit of NATO, and very important bilateral meetings during NATO summit. Yes, we arranged that even in these very difficult times, our president and our team has been welcomed by the Secretary General of Council of Europe and Parliamentary Assembly of the Council of Europe yesterday. So agreement was signed. So it's truly historic event of really global significance. The agreement is signed, and the tribunal is the first of its kind for the crime of aggression since Nuremberg trials following the Second World War. And this agreement is far more than legal document. It is bold and unwavering commitment to justice, accountability, and rule-based international order. With this help, with this step, we are not only making history, we are shaping the future of international law. The crime of aggression is the root of all other war crimes in this conflict, in this war. It is the primary crime, the decision to invade the peaceful neighbor, which led to Bucha, Mariupol, deported children and bombed hospitals. While the ICC investigates war crimes and crimes against humanity, it cannot prosecute aggression to Ukraine under current limitations. We all know this. So this tribunal fills the gap and ensures those at the highest level who unleashed this war are held accountable. Under the Council of Europe's auspices, the tribunal will be international, independent, and aligned with the highest standards of fairness and human rights. It sends a clear message that no aggressor is above the law. And unlike other international institutions and organizations, the Council of Europe demonstrated exceptional principledness and determination in condemning Russia's aggression against Ukraine. It was the Council of Europe that expelled the aggressor state from its ranks, becoming the first international organization to do so. It also showed leadership in the matter of reparations for the damage caused by Russia to Ukrainian citizens by establishing the Register of Damage, the first step in a comprehensive compensation mechanism. This register, operating under the Council of Europe, is already documenting claims, destroyed homes, burned fields, shattered lives. It gives voices to the victims and preserves the truth. So the next step in creation of special tribunal is the accession of states to the enlarged partial agreement, which will be open not only to core group participants and Council of Europe member states, but to all countries. Once again, about international nature of this tribunal to prosecute and punish those who illegally invaded Ukraine, and also to be seen as an effective deterrent instrument internationally, globally, to prevent future aggressions worldwide. This enlarged partial agreement will regulate the financial and administrative aspects of the special tribunal's functioning. So in terms of financing, we count, of course, on support of the partners who have been with us from the very beginning of the process of establishing of special tribunal. We expect the tribunal to become operational in 2026. We do utmost in order to make it happen. Here in The Hague, and you know that the Netherlands many times publicly confirmed their readiness to host the special tribunal for the crime of aggression. Of course, some official and legal decisions should be taken in order to make it happen. But I will say what I can say. So the preparatory work is going on throughout months in order to prepare everything for The Hague to host special tribunal for the crime of aggression. I think that yesterday and the day before events here in The Hague and later on in Strasbourg is a clear evidence that the whole free world is united in order to achieve just and lasting peace in Ukraine, in order to use all instruments in hands to make it happen as soon as possible, and at the same time to ensure that victims and survivors of this war of aggression will have their matter of justice, not only for war crimes, not only for crimes against humanity, which are massive, but also for the leadership crime, the crime of aggression. Because our fight for our freedom on the battlefield and in the courtrooms for justice are equally important for Ukraine and for the whole free world. Thank you, dear colleagues.
Thank you, Ambassador Kostin. That's really fantastic. What I draw from your remarks is this idea that this tribunal has many, many mothers and many fathers, and that international criminal accountability and justice requires a village, if I may say, a global village, for all of us to come together to create these kind of mechanisms. I think what I'd like to do now, if I could, is just turn to Ambassador Scheffer. So just thinking back, David, a little bit about how we got here, can you just set the stage for us so we all understand what is the crime of aggression? Where did the notion that this should become a crime come from? What is the definition? What are the legal authorities? The Kampala review is coming up. What is that all about? Just kind of educate us, if you will.
And all in 7 minutes, right?
Yeah.
Okay.
And I am watching my clock.
Okay, very good. Well, first, it's a great honor to be with Mark and Jessica and Michael and Ambassador Kostin. It's so great to see you again, and also Special Prosecutor David Crane. Can you hear me correctly? Yep.
Okay. We can, David.
Yeah. All right. Very good. Well, what I'm going to do, because I know I have an audience here of incredible experts, and then some who might not be incredible experts on the crime of aggression. So I have to kind of bridge between you two, and I'm going to do it in about 7 or 8 minutes. We are in the 80th year of the crime of aggression. And I think it's remarkable that on June 25th, yesterday, the 80th anniversary of the crime of aggression essentially has been honored with the creation of the Special Tribunal on the crime of aggression against Ukraine. And so we're at another one of these incredible historic moments. It has been, and I'm only going to go back 80 years. It has been an incredible 80 years. it's sometimes forgotten that before we had the London Charter, before we had the Nuremberg trials in 1945, we had the UN Charter, the text for which was completed 80 years ago, yesterday, or tomorrow, I think, June 26th is tomorrow.
Today.
Or today, yes, okay, today. June 26th, it was signed in San Francisco. And in the UN Charter, there are two references to aggression. The first is in Article 1, the purpose, that the purpose of the United Nations is to suppress acts of aggression. Article 39, the Security Council will determine when an act of aggression occurs. So aggression was firmly implanted within the UN Charter. Then we go forward a couple of months to August 1945 and completion of the London Charter, which was the charter for the Nuremberg Tribunal. Now, they were not prepared, all of those dicey lawyers in the room, including Robert Jackson from the Supreme Court, to collectively agree to literally have the quote-unquote crime of aggression. They called it crimes against peace. However, in the London Charter, when you look at the definition of crimes against peace, it says, namely, planning, preparation, initiation, or waging of a war of aggression. So aggression is there. It's in the London Charter. It's just that technically the Nuremberg courts did not technically use aggression in terms of the indictments and then the convictions. The Nuremberg trials themselves, remember that Justice Jackson, his primary thrust at Nuremberg was aggression. That was his priority. Crimes against humanity and war crimes, fine. But for him, the historic character of Nuremberg was to prosecute essentially the crime of aggression. And he made that very clear. He was sidelined a bit because the Holocaust tended to overwhelm the public's, attraction and attention to Nuremberg as the evidence came out on the witness stand and otherwise. And Sir Shawcross of the United Kingdom, part of the prosecution team, did try to establish, well, how do we have individual criminal responsibility for the crime of aggression? And he went back to various treaties, including the Kellogg-Briand Pact of 1928, to try to establish that, look, if this is a state responsibility crime, the only way state responsibility occurs is through individual criminal responsibility. And so he made that point, and that prevailed essentially in the judgment of the Nuremberg trials. The Tokyo trials relatively immediately followed. And there, the crime of aggression was one heck of a fireworks show for 2 years in the Tokyo trials. And in fact, 3 judges ended up dissenting on the final judgment on the issue of whether or not the crime of aggression, in fact, is a crime under international law. But the Nuremberg precedent prevailed, and a good number of defendants at Tokyo were, in fact, convicted and sentenced for the crime of aggression. Then we can jump forward, if I may, to 1974, when the United Nations adopted its resolution 3314, and it did it by consensus in the General Assembly, which of course is a non-binding resolution, but it's nonetheless a General Assembly resolution, whereby the aggression itself was defined in terms of state responsibility. But those factors within 3314 were then incorporated in the later work of the ICC and now the Special Tribunal with respect to individual criminal responsibility. The one thing that didn't prevail in those later courts, ICC and Special Tribunal, is that in the 1974 definition that the General Assembly put out, they had a caveat, Article 7, that said, if you're in pursuit of self-determination, you can ignore all that preceded us here and just go for it. Use violence, use force, if you're in pursuit of self-determination. This was right on the cusp of the collapse of colonialism and the emergence of so many new nations. And it was obviously an equity that was pursued very hard on the floor of the General Assembly. That really has not survived into our current modern war crimes tribunals at all. Then I just want to spend a minute on the International Law Commission, 1994. Some of you may not know that there was originally a statute for the International Criminal Court debated for 2 years and drafted in the International Law Commission, the UN body of legal experts. And they produced a draft, and at this is the point where I came into the whole issue in 1993 because I was with the Clinton administration at the time. And this is what we started to focus on very, very sharply. What was the ILC doing with the entire issue of individual accountability for the crime of aggression? Our man on deck was Bob Rosenstock, the former legal counsel at USUN. So we kind of knew what was going on in all of those discussions. I will say this, that the crime of aggression is solidly in that draft of the ILC, but it's there with the caveat that, I'll just read it to you, a complaint of or directly related to an act of aggression may not be brought under this statute unless the Security Council has first determined that a state has committed the act of aggression, which is the subject of the complaint. In other words, reminding us of UN Article 39. And then no prosecution may be commenced under the statute arising from a situation which is being dealt with by the Security Council as a threat to or breach of peace or an act of aggression unless under Chapter 7 of the Charter, unless the Security Council otherwise decides. So you had a huge Security Council check on pursuing a crime of aggression. Then we come in 1998 to the Rome Statute. The crime of aggression, although it is listed there in Article 5, there's nothing else about it elsewhere in the statute. And the reason is that it was not operationalized in 1998. We could not reach agreement in Rome and in all the sessions prior to Rome, believe me, for 3 years, on a definition for aggression. It was not possible to get enough coming together to just dump the Resolution 3314 definition of 1974 into the Rome Statute. The US position at the time, which has sometimes been somewhat mischaracterized, we were prepared to embrace the crime of aggression in the Rome Statute. The issue that we had was precisely how is this crime going to be defined and be precise. And we couldn't get an agreement on precision. Our basic position was, if it's Poland 1939, we're on board. That's aggression. If you can define Poland 1939, September 1st, 1939, Poland and Nazi Germany, and that's aggression, we're on board. But other parties in Rome wanted to go further than that. And so that created a gridlock among many on our side of the ledger for that argument and those on the other side of the ledger. And so we didn't get it. But then 10 years, or actually in 2010, came the Kampala process, whereby it was enabled under the Rome Statute to then get serious about the crime of aggression, get it properly defined and operationalized. There were many years of sessions before that, particularly at Princeton, where everyone came together to talk except the United States, because under the George W. Bush administration, there would be no presence in any of these discussions. I actually went as a private citizen professor, and I'll just tell you that sometimes I was sitting on the back row, and the guy in the front, would yell back, Ambassador Schaffer, we know you're not with the administration, but what do you think they would say about what we're discussing right now on this particular point? What do you think they would say? But in any event, the Kampala process came, and that was a very intense, I was there, very as a observer, and it was very intense, lots of ups and downs, but finally a definition was arrived at. It had some caveats, very controversial, including the fact that if you're a non-state party, then you're not responsible, or your citizens, for committing the crime of aggression within the scope of the jurisdiction of the Rome Statute. And that's exactly why there is a special tribunal for the crime of aggression against Ukraine, because it's not squeezed into the Rome Statute, given the fact that the aggressor is Russia. I think there's a lot of jurisdictional stuff that's interesting in the Rome Statute that one could talk about in terms of the procedures of how you actually initiate under the amended Rome Statute a case on crime against aggression. But that's not available in the case of Ukraine. So I will leave it at that.
David, thank you. That was quite a tour de force in 7 minutes flat, I have to say. Excellent work. I have some follow-up questions, but I'll save them for the end. But I should say to the other panelists, if you have kind of crosstalk questions for one another during the presentations, don't hesitate to raise a hand and we can engage right in the moment. But if there are no questions, I think that I will turn now to our last, but certainly not least of the Davids, David Crane. And David, David Shepard has talked a little bit about some of the nuances of the negotiation around the tribunal. And of course, every tribunal needs a set of rules. It needs a statute, it needs various rules of evidence and other things. And I know you've been involved in some of the thinking around that. And I wondered if you could take us through some of that process to the extent that you've been involved, but also the way in which the dialogue around that process has taken lessons learned from the past, from past tribunals. So I'll turn the floor over to you, David.
Well, thank you, and I hope you can hear me. And it's always a pleasure to be on any panel with my friends and colleagues who I've known for decades. And here we are again, new tribunal. This is amazing because the international community doesn't form tribunals other than reluctantly. What I want to talk about very quickly is some givens. Having been involved in this, like my good friends Mark and David, for almost 3 decades, there are certain givens, not cookie cutter approach, but there are givens when you're thinking about creating a tribunal of any way, shape, or form. And there's no cookie cutter approach to creating tribunals and courts. But here's some givens that I've kind of picked up on over those many, many years. And that is, and the first what I just said was that the international community doesn't like to set up tribunals. They're reluctant partners. When we have an atrocity and something has to be done, there has to be that political will. But really, the international community doesn't ask the question, or does not ask the question why we should set up a tribunal. They usually ask the question why we should not set up a tribunal. And Andre kind of actually mentioned that as well in his important opening remarks. The bright red thread of setting up an international tribunal is politics. It's a political decision, not a legal one, to set up justice mechanisms. Politics is in the DNA of all the tribunals and courts that we've been involved in, and David and I have been very much involved in setting up many of those courts. Tribunals are creatures of political compromise, and I would venture to say that at the end of these processes that we've been going through Rwanda, Yugoslavia, Sierra Leone, Cambodia, etc., the Special Tribunal that we've just inaugurated, at the end of the process, few people are happy with the result, but it's a result. And I think that's important, that despite all of this reluctance, we do create these tribunals when there's a political will to do so. It's back in June of 2022, we brought together, with those givens in mind, we brought together a high-level working group to discuss what potentially an aggression tribunal would look like. And that high-level working group was Ambassador David Sheffer, the Honorable Erwin Kotler, Ambassador Hans Corell, Prosecutor Richard Goldstone, and myself, along with a representative from the Ukraine Bar Association. We began to discuss what would one look like, how would we do it? And so we developed a task force around the Global Accountability Network, and what we did was, in fact, develop, using the UN General Assembly as a way by which politically we could start the process, because the Security Council was out of the pocket because one of the perpetrators was a permanent member of the Security Council. And so we created a model UNG, a resolution authorizing the Secretary General to enter into a bilateral agreement with Ukraine. And we also created the statute that bilateral agreement would be based on. And that was discussed, and that began to work its way through the system, so to speak, publicly and privately. But we sensed a reluctance again. The conflict in Ukraine ebbed and flowed. Politically, it ebbed and flowed. Support ebbed and flowed. And so it was a constant give and take as to what was the right moment to actually get this resolution. Now, throughout all this process, the General Assembly had passed resolutions in support of Ukraine, and the average was 140 to 141 nations actually supported these resolutions. But the concern was, and rightfully so, in our discussions with Ukraine, is we can't fail. In other words, we've got to get this right one time. And so we didn't press it during 2022 and into 2023, only because we were concerned. We had to have it exactly the number of nations, 2/3, to get this through. But because of this reluctance and one of our themes in this high-level working group and working with other members in the UN, what have you, was we pressed the point is we've done this before. This is not a new process. We have the jurisprudence. We've got the experience. We've got the proper rules of procedure and evidence. This is not a new idea. And so with using generally the Special Court for Sierra Leone as a general model, we put together 7 steps on how to create the UN General Assembly Special Tribunal for the crime of aggression against Ukraine. And that was moving forward until October and then of course during this time frame, the all-important working group, the core group was put together, and they began to do their considerations. We had to have this as well, and so there was mutual discussions on what we do about the crime of aggression against Ukraine. But we, in 2023, in October 2023, we were kind of on the cusp. We were about ready to move with the UN General Assembly when we had the tragedy in October of 2023, the massacre in Israel, and literally the political wind went out of our sails. I mean, literally, the world moved on from Ukraine at many levels, to include the efforts that many people, as Andrei was talking about, working together to create something to account for Ukraine or for the aggression. So I remember convening a meeting with David Sheffer at the Cosmos Club in DC, just around the corner from Tiller House. And I looked at him and I said, where do we go from here? Why don't we create a multinational court, center it in Europe, and have a group of member states of the UN create a court, just like they did at Nuremberg. And so that began further discussions, and we developed and shaped and molded our thinking and our paperwork related to a European-centric, but yet one that had international character to overcome the sovereign immunity challenge. And so, that continued with the core group and the discussions that were going back and forth, and Jessica was very much a part of that. But the bottom line is that was moving forward, the challenges being obviously head of state immunity as one thing, and so that was really kind of the big rock in the road, is what do we do with Putin? And now, in the end of 2024, all of a sudden we had a compromise, and it was agreed to, and now yesterday we had assignment of an accord creating the special tribunal on the crime of aggressions against Ukraine. Significant moment, a significant moment. It's not perfect. It's not the way we exactly want it. We can't actually prosecute Putin, but the political victory is if we can indict Putin and then prosecute those around him for what they have done to Ukraine. That's good enough for now. That sends an important signal to other tyrants around the world who are watching like crocodiles about what we've done with the crime of aggression against Ukraine by Russia. And so now we have sent an important signal to all of them saying, if you invade another country without legal authority, you are an aggressor and you will be held accountable for that crime. So, that's kind of in a way, I mean, it was interesting as we were going through this process in the background, because our high-level working group was very much in the background advising and writing and discussing and advocating the questions, the concerns, the hand-wringing, lots of hand-wringing in creating a tribunal, were almost identical to what David Sheffer and I were faced with when we created the Special Court for Sierra Leone and other tribunals. It's the same kind of questions, and throwing a lot of dust in the air in the hope that this would just go away. Again, with the note that the international community reluctantly creates tribunals and courts, and not does so easily. But this time, Europe came together along with other core group members and Ukraine and created something special. So I'll just leave it at that and look forward to questions afterwards.
That's great, David. Thank you so much. I certainly have questions, and I would encourage those of you in the audience and joining us online also to be thinking about your questions, because we will turn to those in 15 or 20 minutes here. Mark, David already hinted at this a little bit, this notion of political compromises that were made in this particular context. And it's the 80th anniversary, as David has told us. We just crossed this monumental threshold yesterday in Strasbourg. So it really is a moment of triumph for all of us, I would think. But at the same time, it has come at a cost. And I wonder if you could talk to us a little bit about what those costs were, those political compromises, and were they worth it at the end of the day?
You know, one thing I just want to reiterate, David bringing up this amazing situation that we're here on June 26th, 80 years from when the UN Charter was signed. That's extraordinary. And to also couple that with what happened last night in Strasbourg, this is a significant moment that we're sharing, I think, in international law. In addition to those articles that David had mentioned, I was going to come back to Article 2 of the UN Charter. It talks about the prohibition of the threat or use of force against the sovereignty or political independence of any country. And of course, that's what we have seen.
Mark, could you pull the microphone just a little closer for us? That's great. Thank you.
With Russia's aggression against Ukraine. So again, extraordinary period to be able to discuss these points. The compromises, and David Crane had mentioned this, is kind of the political aspect of this is absolutely relevant to the creation of this tribunal, and particularly with the statute of the tribunal, which really will give you the inside awareness of how this tribunal is going to work. And no doubt the most contentious issue in creating this tribunal, there are several, but I think the most contentious was this issue that has been mentioned about this head of state immunity. Whether or not the tribunal will uphold this customary international law principle that the troika, the sitting head of state, prime minister, foreign minister, would be protected from any type of an arrest warrant or an attempt to bring them to justice or sitting in their office. And during the various discussions, Jessica will have a front seat on this, but I was aware of it also in my engagement with Ukraine. There's a core group, and then there was something called a hard core group. So this gets interesting. The hard core group were about 10 countries that were absolutely adamant that this tribunal cannot recognize this principle of head of state. I mean, we needed to move on from that. And of course, it would have been included Baltics, Romania, Poland, about 10 countries, not unusual. So, so you had that, and then on the other side, this is the politics, you had the G7. And the G7 were not too open to saying, well, we're going to create a tribunal, support a tribunal that would recognize or would abolish this head of state immunity principle. So there's one of your biggest political debates. And that's when you had this compromise. there will be many people who will be critical of this compromise. I'm not one of them. And there are many actors within civil society that are and will be critical of this compromise. Again, I'm not one of them, nor is the International Bar Association, because the political compromise was needed in order to accomplish what was accomplished last night. And it is unique in what this compromise creates, I think. And when you look at the statute, it's interesting. It sets forth language that clearly states the tribunal is not going to recognize this principle of head of state. This is the language. For the purpose of the statute, the official position of any accused person at the time of the alleged commission of the crime, whether as head of state or government, shall not relieve such person of criminal responsibility nor mitigate punishment. So you take that language, you say, okay, well, this is going to be quite striking, because the tribunal is saying we're simply going to move away from recognize the head of state immunity in the same way that international courts have been able to do that. But this tribunal, as broad as it is, was thought not to have reached this necessary level for it being seen as an international court, and therefore not to be too concerned about this head of state immunity issue. Plus, again, as I said, you had the G7 that was not going to support it. And then you moved into this really fascinating compromise, I thought, because the prosecutor will be able to investigate and indict these three individuals, as they're sitting in their seats in the current position. So that's really important to pause on, because that's saying that the prosecutor is going to move forward and will investigate and set out indictments, for these individuals who are protected by the head of state immunity principle. This is where it compromises again. That indictment would come to a pretrial judge, and generally you would have a confirmation of that indictment or that arrest warrant. But the tribunal will not do it. Under the statute, the pretrial chamber must suspend any further actions. There will be no arrest warrant against those three individuals or any other sitting head of state, for instance, or any other official, whether it's in Belarus, North Korea, whatever it might be. And they will have to stand back until those individuals are no longer protected by head of state immunity. And that's not going to be anytime soon. But I think Ukraine recognizes that. I recognize that. And that to me is acceptable, because international law plays the long game. And Milosevic, Heritage, Saddam Hussein, others, and I lived in Yugoslavia. I remember those days. I would have ever thought that an individual like Milosevic was ever going to find himself in front of it. Never. But things change. Countries change. Personalities change. Support changes. So this is what you have to hold, that eventually individuals will be brought to justice. Secondly, you will be able to pursue other individuals. The tribunal will pay attention to number of other individuals that are in position that were part of planning or executing this crime of aggression. So it's not just these three individuals. In that, there is no recognition of any head of state immunity, any immunity issue. I think you'll see a great deal of action on that. Finally, another kind of compromise that occurred in this debate, that's been criticized a bit by the international community. Again, I'm not one of them. This tribunal will be able to conduct trials in absentia. That's really interesting. It's a concept, a principle that has a legal foundation, particularly within Europe, within civil law systems, and this tribunal recognizes that. not for those protected with head of state immunity, as I said earlier, but for all the others, tribunal won't need to concern itself with whether or not it has been able to apprehend those individuals. As long as there is an effective notice to secure the individual, as long as there's representation for that individual, and as long as there's an opportunity to retry that individual. So I think you'll see a number of trials taking place within the tribunal, and I think that's very positive. Last 3 points for me, quickly. I'd always hoped that the tribunal would create a defense, an independent defense office, because this is the direction that we've moved in international law. They're not doing that. It will be under the registrar's office, and it will provide the type of international standards that are required, but not an independent one. Victims will be represented collectively at these trials. That's really quite positive. And the final point that I think everyone's going to have to keep their eyes on is getting back to David Crane's point, the political part. Will this tribunal become a bargaining chip for ending the conflict between Russia and Ukraine? This to me is critical. I think it's less likely, because that's why it's so critical, I think, to get this tribunal over that hurdle that happened last night. I think seemingly unlikely that now Europe is going to pull that away as a bargaining chip. But I think that needs to be looked at, and we need to keep our eyes open. I'll leave it at that.
Thank you, Mark. That's really helpful, and especially, in the context of what David said earlier, all of these things are political creations at the end of the day, as well as legal creations. So before I turn to Jessica, I just wanted to remind those of you who are online with us that we will turn to questions in about 10 minutes or so.
David has his hand up.
Oh, sorry, David, do you have a question?
No, just real quick.
Go ahead.
If you can hear me, and I'll just take a quick. The key to understand here is that an indictment of Vladimir Putin and the Troika, should that come in the future, is a political victory. It is important. A indictment there's no statute of limitations, so he's indicted for the crime of aggression, as will potentially his Troika. So that's really important. And there are many other ways. At the end of the day, as these trials move forward, starting in 2026. And subsequent, Vladimir Putin is going to be prosecuted. He's going to be all over these indictments. He's going to be all over the evidence. So he's going to be named and shamed throughout all of this process, which has huge political impact on his stature, whatever stature he has left on him. So, this is, there are many ways by which a prosecutor can do to really technically or figuratively prosecute Putin, even though he's not in the dock, using various techniques that experienced prosecutors do. So just some points there.
Oh, that's really helpful. And I'm going to have a follow-up question for the whole panel about sort of the way in which we parse immunity towards the end. But I'm going to turn to Jessica. But before I do, I just wanted to remind those of you who are online with us that if you do have questions, and we will go to questions in about 8 or 10 minutes here, the way to express those questions is through the Q&A box that you'll find on your screen. So now I'd like to turn to Jessica, because again, it's this moment of triumph. We've come so far in 80 years. There are lots of challenges and political compromises have been made, but the tribunal exists now officially as of yesterday, right? Now it has to actually do its job, and that's not going to be easy. I'm sure there are going to be plenty of operational challenges. We have to choose a prosecutor or prosecutors. We have to staff up. There has to be a budget. And then how do they gather evidence? I mean, there are a lot of operational issues that a court needs to overcome in order to accomplish its goals. And I wonder if you could speak to that for a moment.
Of course. So I want to add on to what's been done to date, meaning today. And of course, what happened yesterday was instrumental in that. And then shift more to what still needs to be done going forward. So a critical part of what's been done to date is operational elements. Ambassador Kostin mentioned it when he served as Prosecutor General of Ukraine. Back in June of 2023, the European Commission launched what's called the International Center for the Prosecution of the Crime of Aggression Against Ukraine, also known as the ICPA or the ICPA. And the reason that was created was such that while these international discussions were taking place to establish a tribunal or whatever would be created to try these cases, we were not wasting any time putting together those cases while the armed conflict was ongoing. And so a team of investigators and prosecutors from different countries, including Ukraine, and until recently, the United States, was based in The Hague at Eurojust, the EU Agency for Criminal Justice Cooperation. And what they've been doing is building an investigative and prosecutive strategy to build essentially a preliminary prosecution package for cases that can eventually be transferred over not only to a dedicated special tribunal, but also to maybe an international court and also to national courts that have jurisdiction over the crime of aggression. Key elements of this team's work, they've been collecting, securing, and analyzing evidence and getting this package together, the main goal being whenever the special tribunal opens, on day one, the prosecutor and his or her team is not going to have to start from scratch. And this evidence has been secured, over time, even while the conflict was ongoing, such that on day one, they'll be ready to move forward with something. And that team continues to work very hard. And until recently, that was my goal. I have to stop because I forgot to disclaim that I am here in my personal capacity. And of course, none of the things that I say necessarily reflect the views of the Department of Justice or the United States government. But I am going to speak about my personal experiences as the special prosecutor for the crime of aggression. And that was my role. I was the US representative at this center based in The Hague, working with this team of investigators and prosecutors to build cases on the crime. Related to that, of course, I served on the US delegation for the core group of states to establish the special tribunal. And that group has been meeting since early 2023, culminating in what you're now seeing signed yesterday. And so there are 3 governing instruments that the core group discussed, negotiated, and the text became public yesterday. The first document being the bilateral agreement between Ukraine and the Council of Europe that was signed yesterday. And what that agreement does is it basically confers Ukraine's territorial jurisdiction to the Council of Europe to create this court. The second document is the statute that will govern the tribunal. So that sets out the jurisdiction, the immunities, the prosecutor, registrar, defense, the rules and procedures of the tribunal. And then the third document is the enlarged partial agreement, and I'm going to refer to it as the EPA. So that takes us into, what happens next? What do we need to still do to move this forward? And there are 3 key steps that have to happen. So the first happened yesterday. The Secretary General of the Council of Europe has to sign the agreement, which has been done. The second thing that needs to happen is that Ukraine then needs to inform the Council of Europe that they have undertaken and fulfilled all of their obligations to ratify the agreement that was signed yesterday, which I am confident that Ukraine will do. And then the third and most challenging aspect going forward is going to be establishing this enlarged partial agreement. And what the EPA is it's essentially a membership agreement for countries to enter into to join the tribunal. It sets out the rights and responsibilities and commitments of each state, not only politically, but also for cooperation and financials. And that's what's going to take the most amount of time for a few reasons. The first is most states have to undergo their own internal procedures for getting this approved to enter into the EPA. If you're not familiar with an EPA, this is an instrument that the Council of Europe uses. It's basically an enlarged membership agreement so that member states of the Council of Europe, of which there are 46, they can either opt in or not. And it's also broader than just Council of Europe members. Any state can join this enlarged partial agreement. The point being that it broadens and hopefully will gain international legitimacy by encouraging more and more states to join. But it's under the auspices of the Council of Europe, but has its own budget, its own governing structure, etc. So that's going to take some time for each state to negotiate whether they're going to be able to join politically and how they're going to support it through what contributions, especially financially. And that brings me to the next bigger challenge, which is the budget. The budget is a core part of the enlarged partial agreement. This tribunal, it's expected that it's going to match or exceed the budget of all special tribunals, and that is a lot of money. And I think there are, we need to think about who's going to be contributing and how they're going to be contributing. And that budget is going to be a key part of actually establishing and getting the enlarged partial agreement passed. And then the third kind of main aspect of the EPA that I think we need to be focusing on is cooperation. So one of the parts that states enter into these EPA, they also need to enter into cooperation agreements. Essentially, how are they going to help this tribunal? What are they going to contribute beyond financially? And there's a provision in the draft EPA right now that basically says the host agreement, so the country that's going to host this, it's conditional, it won't go into effect unless a minimum number of cooperation agreements have been concluded. So that's basically saying we're not going to exercise jurisdiction over this tribunal in the Netherlands or wherever unless a certain number of states commit to providing cooperation in a certain number of areas. And the EPA outlines three main areas of cooperation. First, witness protection, including security and relocation. Second, the enforcement of sentences. And third, release, including interim release. And this, I think, is a clear example of how a country like the Netherlands that has hosted a number of these international mechanisms has learned what works and what doesn't. And this is also a way for the tribunal to gain further international legitimacy by states agreeing to cooperate on all three major areas of cooperation or just on one or two. And then that leads me to, how can we be helping? What can we be doing individually and more collectively to move this forward? So when I talked to the Council of Europe earlier this week, it depends on where you are and what country you're in and what that country's position is, but certainly voluntary contributions by states are going to be very helpful. And particularly, like an example is the Council of Europe's legal team is mighty but small, and they have been working tirelessly to get us to this point. But they're going to need more people, more resources. So to the extent that states can make voluntary contributions via the form of secondments of personnel or other resources, that's certainly something to consider. Another way is exactly what we're doing here today, like institutions like the American Society for International Law and the International Bar Association. These international institutions can help support moving this tribunal forward by getting the message out there and making sure that people are aware of it. And that's the other way that we can be helping, which is through advocacy. We can all be making noise about this, making sure people are aware, making sure our Hill friends know and what's going on. Because as Mark said, international justice is a long game. Administrations come and go. It's going to take a long time for these cases to move forward and for the tribunal to still be established and up and running. You never know what can happen, whether here or elsewhere, and who can be supporting this effort. And if I could make one final point on advocacy, I encourage everyone, if you're interested in this, read the text of the governing instruments. When you're amplifying and making noise and spreading the message about this effort, it's critical that we're spreading accurate information. You have to know what you're talking about, otherwise you can end up doing more harm. So one example that I would provide is, I've heard a lot already about the prosecutorial independence and discretion of the tribunal. There is a critique that because Ukraine has entered into this agreement with the Council of Europe, Ukraine will essentially be able to cherry pick all of the cases that the tribunal will investigate and prosecute. If you look at the text of the statute, that is untrue. So Article 23 governs how the tribunal is going to get cases. It is through a referral system, not a transfer of proceedings. So the way that it works is the Prosecutor General of Ukraine can refer a proceeding, information, or evidence to the prosecutor of the tribunal. The prosecutor of the tribunal then, based on that referral and any other information or evidence from any source, can decide whether or not they want to extend that referral or limit it. And at any point in time, the prosecutor has the discretion and independence to take a look at it and revisit it and decide whether to limit that investigation or not. So these are the kinds of points that I think are critical to be making publicly, so people are aware what are and are not the limitations of the tribunal, and how can we be amplifying it such that we're all contributing to helping play a role in delivering justice in this way.
Thank you. Thank you so much, Jessica. I have a series of three questions that have come up in my mind, so maybe I'll lead off with that. But there is a question that's come online that I think can be directed to you immediately because it picks up on your most recent remarks, and understanding that you're not speaking in your role as
My former
role, DOJ, just to be clear. The question is simply, will the United States be joining the tribunal, and does this matter?
I cannot speak for the United States. Again, I'm here in my personal capacity. Does it matter? I think it does matter. It matters because the United States is a critical part of the G7. As Mark mentioned, the G7 has had a lot of influence in this process, whether good or bad. And it matters for international legitimacy, as well as the fact that the United States has a unique role throughout history in terms of international justice. I mean, we played a big role at Nuremberg and in the Tokyo Military Tribunal. And a lot of people aren't familiar with the American military tribunals after World War II. But though the series of cases there really held accountable different aspects of what we would probably call hybrid warfare at this point, like companies, manufacturers, medical institutions, people who contributed to the crime of aggression related to World War II. And we're going to have a similar, I think, issue in this context with Russia's use of hybrid warfare. So does it matter? I think it does. But as I said also, administrations aren't forever. President Zelenskyy has said before, when he was asked before the last election, are you worried about an administration change? He said, administrations come and go, but I am confident in the support from the American people. And I think everyone in this room today shares the way that I feel, which is we continue to support Ukraine and we will continue to do so until justice is delivered.
Michael, could I add one point? Jess, I think, as she says, can't speak on what the administration would do or not do. I'll go ahead and say this administration is not going to become a member, a member of the tribunal. The administration dramatically pulled away, as you know, when President Trump was elected. So there's not going to be any, for the foreseeable future, no interaction. As Jessica says, things change. But one thing I think it is important to say, the United States hasn't pursued a policy to kill it either. The tribunal continues as it happened last night. It moves on. You're not hearing anything from the White House in relations to what happened last night or what has happened over the last month or so. So I look at that in a very positive way, that I think this administration is just allowing it to be. They're not going to actively support it right now. That's pretty clear. But I think they could have made a much bigger noise against this whole procedure, and they're not doing that. I take that as a positive. Maybe I'm too optimistic on it, but I take it as a positive.
Thank you, Mark. That's really helpful. David, I wanted to turn back to you, David Shepard, to just probe a bit further on this issue of definition and help me to understand this better. I mean, when prosecutors get before this court, they have to prove the crime of aggression, which means there have to be some elements that need to be proved based on facts of certain actions that were taken at certain points in time. So I want to ask you about the temporal aspects of aggression. Is it a single act in time? Was it the moment when Putin signed the order to invade Ukraine? Or is it a continuing act and made up of a bunch of small acts or a bunch of smaller decisions? I mean, is every missile fired a sign of aggression, or is that just a separate war crime? I mean, what's the scope of this from a temporal perspective?
Judges have not ruled definitively on that particular point, but I think it strains logic to reject the point of continued aggression. You cannot simply have a procedure, and the documents don't speak to an act of aggression as only constituting the first day. For example, Poland. Is it just September 1st, 1939? Anything that happened after that is irrelevant with respect to the act of aggression during World War II? Of course not. And the Nuremberg Tribunal certainly didn't see it that way either. Also, I just want to stress that the Tokyo Tribunal had enormous bodies of evidence of continued aggression for years by Japan against all of the colonies of the United Kingdom, Netherlands, France, and then China itself, and then, of course, against the United States. So the Tokyo Tribunal certainly did not see it as a one-off situation. I've been arguing ever since the situation began with Ukraine in this phase in February of 2022 that I think there is sort of a gap in international law in terms of how we address this issue. And I'm so glad you raised it, Michael, and that we don't emphasize enough that on the 50th day of the conflict, every trans-border firing of missiles from Russia into Ukraine, every movement of forces from Russia into Ukraine is essentially a continuation of the original act of aggression. It's not disconnected from it. It's a continuing process. So therefore, when that body of evidence is all ultimately brought together for the purpose of drawing up an indictment, I would hope that it's a body of evidence that is a multi-year body of evidence. That is, we don't have a lot of experience on this in terms of the modern tribunals, because all of the ones that I was involved with, other than the ICC, there was no crime of aggression, Yugoslav, Rwanda, Cambodia, Sierra Leone. We never touched that issue. It was only in the ICC context that we did. So we're still on sort of virgin territory here about how to follow through with an actual prosecution and which evidence. And Jessica can, of course, speak to that far better than I can. I've got a few other comments too, Michael, but I'll throw them in when I can.
Okay. No, anybody that wants to jump in at any time. Mark, we asked the question about the temporal aspects. Let me ask about the spatial aspects, because you mentioned the core group and the hardcore group, which is really intriguing. I mean, should criminal accountability and criminal justice belong to those countries that are most immediately affected? So is there kind of a regional aspect to this? In this case, we've seen that, but is that a model for the future? Does it matter that other nations around the world get involved in this tribunal, or is it enough that those who are members of the Council of Europe have come together?
I think the reality is that the regional approach that eventually occurred was important, because that gave the catalyst to create this tribunal. That was the way eventually it went to, as David Crane was talking about, the General Assembly approach, other approaches that emerged. But in the end, it emerged in Europe, and I think that's important. However, it certainly, for me, doesn't stop there, because of what David has walked us through. The crime of aggression is an international crime for me. It goes right back 80 years ago with the UN Charter. So it needs to be international, and this is why this partial and large agreement is so important. It allows other countries to join in. Will that number be equal to the number of European countries coming in? No, I don't think at all. But let's say you get up to 50 countries, get an additional 10 countries that are not European countries. I think that's a powerful statement, and that reinforces this principal position that this is a crime that concerns the entire international community. And if this is not the scenario where the crime of aggression should be prosecuted, I'm not sure what is.
That's good. Thank you. David Crane, I see you have your hand up as well. So I have a question for you, but maybe you'd like to ask a question, make a comment before I ask you my question.
Yeah, just real quickly, we have for the first time, I think, direct support of the aggressor by other nations, heads of state. Aiding and abetting aggression has never been prosecuted, thought of very much in the overall lexicon of our work. And I think that this is a tribunal which can assist in fleshing that out too, to include sending signals to countries that aid and abet an aggressor that they are also opening themselves up to potential criminal liability. So even though the way the statute implies, we're not going over the heads of state of Iran and North Korea and China and Belarus, what have you. There are ways by which we can, and we did this in Sierra Leone, where I named and shamed Muammar Gaddafi and Blaise Compaoré, two presidents of other countries who were directly involved in the destruction of Sierra Leone. And the bottom line is we could do that again through a investigatory as well as an indictment process and prosecution subsequently of various individuals, of naming and shaming these individuals as well as to what their involvement in aiding and abetting aggression.
Thank you, David. My question for you is, when I was listening to your earlier remarks, I had my mind went in two directions. One was that I thought, wow, this is really getting easier. You made the case that, hey, we've done this before. It's not that complicated and we can do it again. But at the same time, I was also hearing, and I've heard from the other panelists how challenging it is. So I don't know if this is a softball question or a hardball question, but is it getting easier or is it getting harder based on your unique perspective?
My point is, as far as we've done this again, we've just done this again. And so we do have precedent. We do have jurisprudence. We have the experience, a very deep bench of very experienced individuals who have done this before. So that was kind of my comment. It's never easy. It's all politics and compromise and doing what is right, and that is seeking justice for the victims of an atrocity. And that's one of the things that we tend to in our discussions today and elsewhere is, this is for and about the victims in Ukraine, the aggression that was wrought upon them. And so this is, at the end of the day, the end state. And I really want to also note that, there are a lot of naysayers. Yeah, this isn't pretty. This isn't perfect. But it's either this or nothing. And so the key being is that we really have to go, okay, I don't like the way this looks. It's compromised to the point of where I'm not sure how effective it's going to be. It will be effective. It can do its work. And that instead of picking at it, why don't you get behind it and let's go ahead and prosecute the best we can based on the statute.
Thank you. I have a couple of questions here online that I'll turn to, and then we'll open it up to the audience if that's okay. We still have 8 or 9 minutes left. So the first question is, maybe I'll just toss out all three of these. The first, and anybody that wants to pick them up. The first is, what are the challenges of establishing and moving this tribunal forward while the crime of aggression is still ongoing? Does that pose unique challenges for us? That's question number one. Number two, and David, you touched on this a little bit, it's sort of aiding and abetting. It has to do with Belarus and their complicity in aggression. Is that before this tribunal? Is that one possibility, I would imagine? So maybe somebody could answer that for us. And then finally, to what extent will the tribunal incorporate victim participation? Maybe that's a good one for you, Jessica, I don't know. But if anybody wants to lead off on any of those three questions. So the ongoing aggression, does that pose a challenge? The issue of Belarus and the victims' perspectives and incorporation.
I'm happy to answer the second question first, which is on criminal liability for officials in Belarus, and I'm just going to broaden it to other countries as well. So Article 1 of the statute sets out the jurisdiction of the tribunal, and it makes clear that it is intended to investigate and prosecute those who bear the greatest responsibility for the crime of aggression against Ukraine. It does not say Russian officials or any other limiting aspects. It says those who bear the greatest responsibility. And without going into details, I can tell you that the team of investigators and prosecutors who have been analyzing and collecting evidence on this crime to turn it over to the tribunal, as well as national prosecutions, they are keeping the same principles in mind. Ultimately, that will be for the discretion of the prosecutor.
One could imagine North Korea, Iran, maybe others involved. We'll see how that
One
happens.
could.
One could. Hypothetical world. Okay, David, I see you. Did you want to say something? Yeah.
Just real quickly, I think it's really important that as the tribunal begins to set up its work, is that they create an outreach program where there is an expansive movement in the region of listening to the victims and let them tell their stories about what took place in Ukraine and frankly elsewhere as well in the region, because that's critical. We did that in West Africa and Sierra Leone, and it was important for the victims. One of the things I learned while being in West Africa is victims want to tell their stories. So I really want to underscore that the focus of this new tribunal, and any tribunal in my mind, has to be justice for the victims in Ukraine and elsewhere related to this aggression. And an outreach program is a very, very important tool by which a prosecutor and others can stand in front of the people and talk to them, listen to them, answer their questions, and do this on a regular basis so that they have some kind of sense of involvement related to where this is all going and an understanding as to how the special tribunal is going to assist them related to the crime of aggression.
Great, thank you. Look, I'd like to open it up to those of you who are with us here today in Tiller House. If anybody has any questions, I see two in the back. Michael, I remember because we had the triangle of Michaels earlier. It's Michael
Sullivan.
Sullivan. Thanks, Michael.
Sure. Thanks for all your comments. I agree with Mark that I don't expect that the U.S. will support this, but I also don't think they'll oppose it. Some things are difficult to oppose, and this administration, they defunded the Yale program where 35,000 children were forcibly deported, but being against it is the second thing. So I would just note when David was talking about kind of the thing that made sense, right, as far as structurally the German invasion in Poland. And so September 1st, 1939, we get that, and it's a very clear thing. And I think what we're talking about here is February 22, 2022, and the Russian invasion of Ukraine. But what Jessica was mentioning really is what I'm thinking about, and words hybrid and the use of other involvement. And I'm thinking of April 2014 and the initial crime of aggression of Russia on Donbass. And a lot of what we talk about here is what it's going to do in the future when people think about, is this going to deter things? And I think the deterrent is even stronger for places like Luhansk and Donetsk, people thinking, are we going to take part in this, as opposed to if you're within the scope of Putin's group. So I thank you very much for pointing that out. And I'll be very curious to see how much that gets involved in all this.
If I could respond quickly, thank you for that instructive comment. And on that point, there is no temporal jurisdictional element in the statute. Like, it could have very well said the crime of aggression against Ukraine from such and such date, maybe February 24th, maybe April 2014. It does not. And I think what that reflects is that the information and evidence and the facts with the prosecutor's direct discretion will lead to the strongest cases being investigated and prosecuted.
So another question, would you mind just to stand so we can all see you?
Yes, of course, thank you. My name is Anastasia Donets. I represent International Rights. I'm a human rights lawyer, and my question is, I really liked your previous remark about the deterrence. And my question is, we already have an arrest warrant against Putin, as well as against a couple of senior military leaders of Russia. Mongolia refused to arrest Putin, and my concern is, although I think this is a historic moment, and I really hope it will work out, not only for the sake of Ukraine, but for the sake of many other countries that are facing potential invasion. If countries do not have the political will to arrest senior leaders, even if they don't have kind of state immunity, what can we do as civil society, as international relations, as policymakers, to advocate that it's shameful not to do it, it's harmful not to do it, and this absolutely has to be done? How do we create this political?
So for those of you online, the question has to do with the issue of cooperation with the ICC and with this tribunal. And for those countries that don't cooperate, how can we compel cooperation?
Mark, you might be best.
Well, you too, David. I'll say just a few words so David can jump in on this. For this, First of all, I think the advocacy or the promoting accountability through these types of mechanisms, we oftentimes in civil society talk about justice, and I'm a full supporter of that. I think that's absolutely right. But there's another element too, and that's security. That if you're in essence saying that we can forego the accountability mechanism for a state leaders who have committed these crimes, then for me it jeopardizes security in the future because it simply says, well, it really doesn't matter. So as difficult as this political hill is to climb, and it is exceedingly difficult, we just have to keep continuing to advocate and push for that degree of responsibility. Let's not get too disheartened either. As David kind of walked us through from 80 years ago, the international community has made incredible strides in this concept of responsibility for atrocity crimes. So this, to me, I take comfort in that, even though there's lots of backsteps. To me, the momentum is in the right direction.
And I can add to that very quickly.
Yeah, please, David.
By just saying that don't underestimate the power of the in absentia clause now in the statute, because once any of the three troika simply lose their office, which may happen sometime in the next 10 years or so, there doesn't need to be an arrest of those individuals, as I understand the statute at this point. They can be tried in absentia once they have lost their immunity under international law. They don't have to be literally physically arrested and brought to The Hague, because they'll probably hide themselves in Russia anyway. So that's encouraging. One very quick remark that I just must say, when Jessica was raising the importance of the budget, I'm afraid I've got years and years of focus on the financing of war crimes tribunals. And I must say that it's extremely important for those in civil society and in sort of the intellectual realm of the war crimes world to understand that nothing happens without the money. Nothing happens. You must have it every day of every year, and for this special tribunal, it will be probably for 20 years. So you need to have someone or some committee or something with an extremely sharp focus, probably out of the management committee, that literally goes after this, because this is all voluntary, and there's going to have to be a budget every single year. Governments will have to be briefed every single year. Don't think you can get by just once briefing a government. When I did it for Cambodia, I was on a plane all year long going to a list of countries to brief their foreign ministries and finance ministries once again as to why the Cambodia Tribunal should be financed. So it's an incredibly important point, and it must be achieved if you substantively want this tribunal to do its job.
That's a very important point, David. And I would also point out that nothing happens at Tiller House without money either. ASIL.org/donate. But listen, I'm also the bearer of very bad news. We've kind of run out the clock, but I would like to give each of our speakers 1 quick minute just for any closing thoughts that you may have. So why don't I start with David Crane online, and then I'm going to end with you, Mark, our co-host. Please, David, any closing thoughts?
Just real quickly, I really want to underscore that this is a moment of victory. It's not perfect, but it is important to note that the rule of law truly is more powerful than the rule of the gun. And this creation of that special tribunal is very, very important. Secondly, this tribunal can be managed effectively. A prosecutor or a leadership team who has a management plan which they can brief to contributors on a regular basis, showing what their money is doing, how it's doing, and why they need more, and for what reason. This can be done. We did this with great success in West Africa with the Special Court for Sierra Leone, and our budget was probably 25% that of Yugoslavia and Rwanda. So it comes down to management 101. Take your mandate, take your people, take the money that you have, develop a good management plan, and execute it. So yes, these things are not cheap, but they can be managed effectively and efficiently, which is, I think, what we showed in West Africa.
That's great, David. Thank you. Jessica, any closing thoughts?
Yes, 2 things. So the first, factually, I just want to point out there are a lot of potential defendants here beyond the Troika. There is significant focus always on the Troika, and we kind of glossed over the term without really explaining what it is. That consists of the head of state, the head of government, and the head of foreign affairs, as well as the Minister of Defense. So that's only though while they're in office. Long game, they're not going to be in office forever. They may be, but they're probably not going to be. And there are a lot of other people who have contributed and can be and should be held criminally liable for the crime of aggression against Ukraine. Noting also that Hitler was not prosecuted at Nuremberg. And the lasting legacy of Nuremberg as this rule of law, justice mechanism continues to live on. And then lastly, thank you for paying attention today and being a part of this. I think it shows, and I would encourage us all, myself included, to continue to think about shifting from talking about the need for accountability and rather to playing a role in how we're going to deliver it.
Perfect. Thank you, David.
My closing thought is on the negotiations. If they occur in a really good substantive way in the near future with respect to Ukraine and Russia, you might look at a piece I published a couple of years ago in Just Security, in which I offered two options. One, you can either proceed with the negotiations and simply carve out international criminal justice and let it go on its own way. Do not bring that issue to the table. It may be disastrous if you do. You have to understand what Russia will demand if that issue is on the table. Let the judicial system operate. It is operating, and the Special Tribunal demonstrates that. So it may not be very wise to at least on the side of the West, bring that issue to the table. As much as it will upset the victim population in Ukraine, it may have to be a separate channel. If you do bring it to the table, then what I try to suggest in the article is, well, how do you handle each of these issues, the children, etc., if these issues are brought to the table as justice issues? But I think we've reached the stage where the separate channel on justice may be the most pragmatic.
Mark, would you close this up?
Well, first of all, to thank Michael for moderating this and for hosting this. It's always fantastic for the IBA to engage with this society. It's a remarkable, it's a remarkable group, a remarkable institution. I congratulate you, Michael, for everything you do. Finally, I would just say, listen, we're now starting the mission now. Even though it's been 3 years for many people involved with this, the real work now begins. There will be fits and starts. There's going to be disappointments. There'll be criticism, but the achievements that have been made to date are quite remarkable. And I come back to one group, and it's the Ukrainians first and foremost. I've taken 10 trips there in the last 3 years. They deserve this. They deserve the international community making sure that this works, and those who have committed the crime of aggression are brought to justice. Ukrainians deserve it. The international community and international law, they deserve it as well.
It's fantastic. Thank you so much, Mark. Look, we're over time, so all that I will do is simply thank you for your ongoing interest in what's happening in Ukraine. Thank you for paying attention to these issues, and let's thank our panelists.